Kees Groenendijk ist emeritierter Professor für Rechtssoziologie an der Universität von Nijmegen. Er hat dort das Center for Migration Law gegründet. Er ist dort auch noch Fellow. Er ist seit Jahrzehnten Mitglied der Meyers-Kommission, eines unabhängigen Gremiums oder einer unabhängigen Komitees, das sich mit Fragen des Migrations-Flüchtlingsrechts beschäftigt. Er hat gesagt, unabhängiger als die Süßmuth-Kommission. Und Kees hat zu fast allen Bereichen im Migrations- und Flüchtlingsrecht publiziert. Und er ist seit Jahrzehnten Gast, Antreiber und wesentlicher Ideengeber der Hohenheimer Tage. Und wir freuen uns sehr, dass wir ihn gewinnen konnten, den Eingangsvortrag zum Bereich Familienzusammenführung zu halten. Und deswegen ohne weitere Verzögerung, du hast das Wort.
Ich bedanke mich für die ehrenhafte Einladung, am Freitagabend in Hohenheim zu referieren. Ich bin froh, die Diskussion mit engagierten Experten hier wieder live zu erleben. Aber ich muss mich entschuldigen, dass ich weiter auf Englisch rede. Auch nach mehr als 35 Jahren in Hohenheim ist Reden auf Englisch noch immer einfacher für mich. Allow me to start with a personal experience which made me the urgency of family reunification and the consequences of postponing reunification acutely clear. In 2015, 4,000 refugees from Syria were temporarily accommodated in large tents near the Nijmegen University campus. My wife and I invited 4 Syrian men for dinner. During the dinner, one of them was constantly trying to make calls on his mobile telephone. He explained to us, "My wife and our 2 daughters are still in Raqqa. In our house, there is no electricity. And my wife, as an unaccompanied woman, is unable to go to the telephone shop. A former colleague just phoned me that the Russians today bombed another quarter of the city." I will never forget the fear in his eyes. It took 6 months before he received his refugee status and another 6 months before the family was actually reunited and could begin to focus on integration in the Netherlands. He was relatively lucky. Many Syrian refugees in the EU were entitled by law to family reunification, but had to deal with governments unwilling or unable to realize that right in practice. They had to wait several years before being reunited with their loved ones and make a real start with the integration in their new home country. Today, most family members coming to the EU have a legal right to family reunification on the basis of EU law. But the recognition and the actual realization of that right is the outcome of a long battle between actors at national and European level. There's a constant tension between the wish of states to decide who to admit and to select new immigrants on their expected economic contribution or presumed ability to integrate in the society on the one hand, and the human rights of everyone to marry and live with the partner of his or her choice on the other hand. This tension between human rights and migration regulation is inevitable. It is a constant source of conflicts and efforts to find a fair balance between these 2 contradictory aims. The focus of my presentation tonight is on 2 questions, a historical one and a normative one. The historic question is, how did the right to family reunification develop and which actors contributed to its recognition? And the normative one is, are the differences in treatment in the current EU rules on family reunification justified? But let's first have a look at the numbers. Since the 1980s, family reunification has become a major round of admission of immigrants in Europe. During the decade 2010 to 2021, the total number of first residence permits issued by the EU member states to nationals from non-EU countries for family reasons varied between 500 and 800,000 per year. Between a quarter to 40% of all first residence permits issued to third country nationals in the EU were issued for family reasons. In 2021, family migration was the most common reason for first admission in 10 of the 27 member states. The member states with the highest numbers of first residence permits issued for family-related reasons were Spain, Italy, France and Germany in that order. The top 5 countries of origin of family members that year, 2021, were Morocco, Ukraine, India, Albania and Brazil. Despite all the restrictive national policy measures, a considerable number of non-EU family members is admitted in the EU each year. In the first major international codifications on migration after the Second World War, the 1949 ILO Convention on Migrant Workers and the 1951 Refugee Convention, there is not a single word on family reunification. The ILO Convention only offers protection against expulsion of the admitted family members of a migrant worker who becomes disabled after 5 years, or 5 years or later after admission. And in the final act adopting the Refugee Convention, family reunification was only subject of a recommendation. When Belgium, France, Germany and the Netherlands started to recruit workers from the Mediterranean countries in the 1950s, they did not have rules on family reunification in their national law. Only rules in their nationality law allowing foreign women to acquire the nationality of their husband at or after marriage. Due to the efforts of countries of origin of the Mediterranean workers, clauses on family reunification were included in some of the bilateral recruitment agreements. In practice, however, these rules produced little effect, either because the workers did not have the required accommodation, or for accommodation for their families, or because immigration authorities and national courts of the recruiting countries interpreted these clauses as being not legally binding. The first national rules on family reunification in the recruiting countries since the mid-1960s were laid down in administrative circulars, often unpublished. Their actual application depended largely on the discretion of local authorities. In the Netherlands, for instance, those administrative instructions were adopted under pressure of employers' organizations. And the result was that wives of Spanish workers were admitted, but only if they had a job and no children. German employers also realized that direct recruitment of the spouses of their workers was relatively cheap and enhanced the chances to retain their trained male foreign workers. In 1960, the European Commission noted in a report the negative effect of the barriers to family reunification on the integration of Italian workers in the other 5 member states. And the next year, the Italian Commissioner of Social Affairs, Leonello Levi-Sandri, managed to include the right to family reunification of workers of other EEC member states for the first time in a binding legal international document, the 1961 EEC Regulation number 15 on the free movement of workers. The treaty provisions on free movement of workers do not mention their family members at all. Nevertheless, the Commission considered the right to family reunification to be essential on 3 grounds. Firstly, humanitarian reasons requiring to maintain family unity. Secondly, family unity strongly assist workers in remaining in their employment. And thirdly, being unable to be accompanied by one's family would be a serious obstacle to free movement. Family unity was not yet formulated as a human right, in EU law at least. But family unity and economic interests explicitly trumped demographic and housing problems in the member states. The right to family reunification was confirmed and extended in the regulations of 64 and 68. The requirement of normal housing was dropped after pressure from Italy against the opposition by Germany and the Netherlands. In practice, however, most member states continued to apply their national rules or waiting periods on waiting periods or housing requirements and did not take the EC rules on family reunification seriously until the late 1970s. Since 1961, the right to family reunification in EU rules on free movement covered the spouse, the children under the age of 21, all the dependent children and the couple's dependent parents, irrespective of their nationality. This wide definition of the family still applies to mobile EU citizens today. In 2004, it was extended to cover registered partners as well. Cases testing the limits of the EC right to family reunification started to arrive before the Court of Justice only in the 1980s. Four of the first five cases concerned the reunification rights of non-European family members of Union citizens. The case Morsen and Jan, the first family reunification to be referred by a national judge to the court in Luxembourg, concerned Surinamese parents of static Dutch nationals. The other cases concerned the Senegalese wife of a Frenchman living in Germany, Diatta, the Togolese wife of a Belgian national, Dzossi, in 1988, and the Indian wife of a UK national, Surinder Singh, in 1990. The fifth case, on the equal treatment of unmarried partners, was the only one concerning the family relationship between two white Europeans, the case Reed of 1985. The other four cases are an indication of the treatment of non-European family members during the first decades after 1968 in the member states concerned. The role of race or ethnic origin in family migration law will come back at several points in my presentation. These rules on the right to family reunification over the decades influenced rights of several large groups outside the personal scope of the early EEC regulations. In the 1960s, governments of third states, national politicians, ministries of social affairs used the EEC model to plead for granting this treatment to other workers. Workers from Spain, not an EEC member state until 1985, should receive the same treatment as workers from Italy with regard to family reunification. The relatively liberal Belgian Immigration Act of 1980 provided that the rules of the EEC regulation on free movement also applied to the family reunification with static Belgian citizens. Similar rules were later introduced in several other member states, thus avoiding the thorny discussion on reverse discrimination of their own citizens. In many countries, citizen sponsors account for half or more of the reunification, account for half or more of the applications for family reunification. Consequently, this extension of the EU rules to family reunification with static national sponsors has far-reaching effects. Not all member states agreed with this extensive application of EU rules, as was, for instance, illustrated by the strong opposition of Germany and the Netherlands against the 1999 proposal of the European Commission to codify this extension to static EU nationals in the Family Reunification Directive. Germany at that time was eager to retain the competence to regulate the family reunification of Spätaussiedler, and the Netherlands opposed this proposal because it wanted to retain its freedom to restrict family reunification of naturalized Turkish and Moroccan Dutch nationals. The prolonged residence of Mediterranean workers, the 1973 recruitment ban, which closed the possibility to return and come back to Western Europe, and the repeated political discussions on reducing family benefits for children living in the countries of origin, all increased the demand for family reunification. The increased value of the principle of equal treatment and the liberalization of family norms influenced the political responses when lawyers and NGOs, such as GST in France and the Interessengemeinschaft mit Ausländerverheiratete Frauen in Germany, started to campaign for more liberal national rules on family reunification. And here we see two different patterns. The first one can be observed in countries like Germany and France, where the highest courts used clauses on family reunification, on family life in the national constitution to annul administrative circulars unreasonably restricting family reunification. In France, this was done by the Conseil d'État in 1978, and the Bundesverfassungsgericht did so in 1987. The second pattern is noticeable in Denmark, the Netherlands, and the UK, where in the national law there is no such constitutional right and there is also no constitutional court. In the latter countries, NGOs, lawyers, and national courts were and are more inclined to look at the European Convention of Human Rights and the court in Strasbourg to perform this role. In 1985, more than 30 years after the convention had come into force, the European Court of Human Rights gave its first judgment on family reunification in Abdulaziz. It held that the UK family reunification rules violated Article 8 and Article 14 of the European Convention because they discriminated between male and female citizens. The complaint about racial discrimination was not accepted by the court. Before that judgment, national courts, before Abdulaziz, national courts in many European countries had ruled that Article 8 of the Convention did not apply in immigration cases. Apparently, national judges were reluctant to interfere and tended to protect national sovereignty in this field. The rule of a human rights perspective in the debate on family reunification was stimulated by further judgments by the court in Strasbourg, in Berahap, 1988, Gül, 1995, both illustrating that Article 8, which guarantees the right to respect for family rights, for family life, not a right to family reunification, could protect admitted family members against expulsion and oblige states to admit family members of non-nationals in need of protection in case reunification in another country is not possible. The three Strasbourg cases, these three Strasbourg cases, originated in the UK, the Netherlands, and Switzerland, all three countries without a constitutional clause protecting family life and without a right to family reunification in the national legislation. These liberal legal developments at European level during the 1980s met with political pressure at national level for more restrictive rules on family reunification. This pressure was induced by the growing number of asylum seekers from outside Europe who, after admission, would now be entitled to family reunification, by the increasing number of children of settled immigrants asking for family reunification, and by the realization that an increasing share of sponsors for family reunification were citizens of immigrant origin. In the Netherlands, already in around the change of the century, half of the sponsors were Dutch citizens of immigrant origin. At the same time, the member states in 1997 in the Treaty of Amsterdam empowered the EU to make binding legal rules on the admission of third-country nationals, including those for the purpose of family reunification. 2 years later, the Commission published its first proposal for a directive on the right of family reunification of third-country nationals. And this proposal was modeled after the free movement rules and influenced by the then relatively liberal French rules. Negotiations in Brussels lasted until 2003, 4 years, especially because Germany wanted first to decide on its national legislation before it would be bound by EU rules on this, in this field. The opposition of some member states against the liberal proposal was reinforced by the increasing anti-immigrant mood after the 9/11 attacks. The result was a compromise, but for the first time, the right to family reunification of non-EU sponsors with their spouse and minor children were codified in EU law if the conditions regarding income, housing or integration were met. These conditions do not apply when the sponsors are refugees. Shortly after the adoption, the European Parliament, which at that time had no legislative power in this field, but was only consulted by the Council, asked the court to annul the directive for violation of the European Convention of Human Rights. The initiative for the Parliament's action was taken by lawyers from the same French NGO, Justice, who obtained the annulment of the Circular on Family Reunification by the Conseil d'État 20 years earlier. In this first case, before the EU Court of Justice, Germany argued that the directive did not really provide binding rules, repeating the minimalistic interpretation of earlier international norms on this topic in the recruitment agreements and in Council of Europe instruments on migration. The court dismissed the Parliament's action, but in its judgment, the court confirmed that the directive provided a subjective right to family reunification, leaving no discretion if the requirements were met, a right going far beyond the protection of family life guaranteed in Article 8. In most member states, the transposition of the directive resulted in more liberal rules on family reunification in national law. By contrast, some member states, for instance France and the Netherlands, used the transposition of the directive as an occasion to introduce new restrictions. Initial opposition among national immigration authorities and courts to the application of the directive considerably postponed the effects of the directive in practice. It took the Dutch Immigration Service, for instance, and the courts almost 8 years to comply with the instruction of the Court of Justice in the Chacroun judgment, the first reference on the Family Reunification Directive, that prohibited strict application of the income requirement. Only after the Cachap judgment in 2016, a reference from Spain, that confirmed the Chacroun judgment, where the courts and the Immigration Service inclined to take this serious. I'll draw your attention for 2 recent examples of this opposition. One of the innovations of the directive was the right of minor refugees to be reunited with their parents. Few, if any, member states provided for this right with reunification with parents in its national law before the adoption of the directive. Several member states implemented this right on paper, but developed practices clearly frustrating this right. In the Netherlands, decision-making was often postponed until the applicant had become 80 years of age, a practice condoned by the highest administrative court. In Germany and Austria, the right was lost by law if the refugee became of age before the reunification. In Belgium, the courts held that the refugee had no longer an interest in his appeal against the refusal of family reunification with his parents after he had become of age. In all 4 countries, lapse of time was used to annul this new EU law right until the District Court of Amsterdam, in open disagreement with the State Council, referred questions on the legality of this practice to the Court of Justice. In 2018, the court, in the case A and S, held this practice to be in violation of the directive. The court anchored the right to family reunification to the age of the applicant at the beginning of the asylum procedure. If he was a minor at that time, reunification can no longer be refused on the ground that he became of age during the asylum procedure or during the subsequent family reunification procedure. This judgment triggered a series of new references from courts in Belgium, Austria, and from the Bundesverwaltungsgericht, all of which, in different words, implicitly asked, "This cannot be true. Please reconsider your position in ANS." In 4 subsequent judgments, the court steadily refused to do so, each time politely explaining its previous case law. Yesterday, I learned that this 5-year-old case law is not yet implemented in the German immigration law yet. The other recent example of this defensive attitude towards the Family Reunification Directive is the use of waiting periods. Many EU member states used formal waiting periods to postpone family reunification of migrant workers in the 1950s, 70s and 80s, waiting periods ranging between 1 and 2 years in most member states, until up to 8 years in Germany for the reunification of children of migrant workers. The Bundesverfassungsgericht in 87 reduced the extreme 8 years to 3 years as the maximum compatible with the Grundgesetz. The Family Reunification Directive further reduced the maximum length for all EU nationals, non-EU nationals, to 2 years. The directive, moreover, prohibits member states to use any waiting periods for refugees. After the arrival in 2015 of large numbers of people fleeing the civil war in Syria, some member states try to reduce the effect of this clause by granting many Syrian asylum seekers only subsidiary or national protection status, which placed them outside the personal scope of the directive. Thus the question arose whether the waiting periods of 2 or 3 years are compatible with the minimum standard of Article 8. In 2021, 5 years later, the court in Strasbourg in MA versus Denmark, a case concerning a Syrian national granted temporary protection under Danish law, held that the 3 years waiting period in Denmark for reunification with a spouse in Syria in a case without minor children violated Article 8. In the judgment MT and others against Sweden, the court in Strasbourg last October held that the de facto waiting period of 1.5 years for the reunification of a young Syrian national granted subsidiary protection status with his mother did not violate Article 8. The court, in that case, took into account that Sweden abolished the waiting period soon after the numbers of new Syrian asylum seekers had gone down. Both cases dealt with formal statutory waiting periods in national law. In real life, a range of administrative practices de facto postpone family reunification for several years in some member states. The Court of Justice last month dealt with that issue in the Afrin case, in a judgment which may be relevant for the practice in Germany as well. The case concerned a Syrian man who received refugee status in Belgium in August last year. He fled from Syria 3 years earlier, leaving his wife and 2 young children behind in Afrin, in the northwest of Syria, an area bordering Syria. An area bordering Turkey. The Belgian immigration authorities refused to deal with his application for family reunification, since under Belgian law, that application has to be filed at a Belgian embassy by the family members in person, even though it was impossible for the applicants to reach that embassy from Afrin. The border with Turkey is closed for Syrian nationals, and leaving the region in another direction would require crossing a military front line. The refugees' lawyer asked the first instance court in Brussels for an injunction against the Belgian state, arguing that this requirement violated the Family Reunification Directive because it made it impossible to apply for family reunification. That court referred that question to the Court of Justice in January, and also asked the court to deal with this reference in the urgent procedure. The Court of Justice allowed that request on the simple ground that the father and his minor children had been separated for more than 3 years. Continuation of that situation resulting from the refusal of the Belgian authorities to deal with the application for family reunification could seriously harm the future relation of the children with their father. That was the only reason to grant the request for the urgent procedure. The court gave its judgment in the urgent procedure a month ago, on 18 April, almost within 3 months, requiring family members to appear in person at the beginning of the procedure when this presence in practice was impossible or very difficult, violates the purpose and effet utile of the Family Reunification Directive. The Belgian requirement is, according to the court, incompatible with Article 5, Section 4 of the Family Reunification Directive, Article 7 and 24 of the Charter, and with the proportionality requirement of Article 52 of the Charter. A member state could require personal presence at a later stage in the procedure, for instance, when the visa were issued. Member states, according to the court, use digital communication, be flexible and facilitate making the application. The court at length referred to its earlier case law on the weight of the interest of the minor children concerned, as it has done ever since the Charter became primary EU law. In my view, this judgment raises questions as to the compatibility of the German rules and practice, resulting in waiting periods for an appointment at certain embassies of a year and more. Thus, clearly more than the 9 months allowed for the total procedures by Article 5 of the directive. According to constant case law of the court, in infringement cases, national law, the federal structure of a member state and its administrative capacity are no valid grounds for non-compliance with EU law. Force majeure cannot justify an administrative practice that already continues for more than 5 years. Article 5 of the Family Reunification Directive only allows for extension of the 9 months in exceptional circumstances linked to the complexity of the examination of the application. Lack of administrative capacity or communication between different national authorities involved by national law are no ground for extension of the maximum of 9 months. So far for the first question, now my second question. Are differences in treatment in the current rules on family reunification law justified? EU rules on family reunification developed over 60 years, since 1961. Currently, these rules are laid down in 11 different EU instruments. Certain categories of migrants in EU law do not have a right to family reunification at all. Seasonal workers, students, those with a residence permit valid for less than a year, or not having a reasonable prospect of obtaining a permanent residence status, and asylum seekers when family members are outside the EU. The short duration of their stay or the precariousness of their residence status are the main justification for the exclusion of family reunification. The rules for other categories of sponsors vary considerably. Different rules for EU citizens and non-EU citizens, for mobile and static EU citizens, for third country sponsors with or without high qualification, and for refugee and those with subsidiary or temporary forms of protection. This patchwork and most of the resulting differences are understandable and even inevitable, considering the historical development, the legislative process of the EU, and the considerable differences in national rules and traditions between member states. Nevertheless, the question arises whether this patchwork and the resulting differences in treatment are legally, morally, and politically acceptable. My plea is for a systematic and critical review of the differences in treatment of third country sponsors with regard to family reunification in the national law of member states, not a plea for revision of the EU legislation. Within each member state, NGOs, lawyers, researchers, immigration authorities, judges, and politicians should critically consider whether the current differences in treatment of sponsors are compatible with the prohibition of discrimination in the UN Convention Against Racial Discrimination and with the more general prohibition of discrimination in the European Convention on Human Rights and in Article 21 of the Charter. I will not further discuss the differences between Union citizens and third country nationals and the difference between static and mobile Union citizens. In the last part of my presentation, I will focus on 3 differences in treatment between non-EU sponsors only on the basis of their nationality, resident status, or education. These differences have to be justified in the light of EU and international human rights standards. The prohibition of discrimination is a human right with the same standing as the human right to family life. First, the difference in treatment between highly qualified workers and other sponsors. As part of a policy to make the EU more attractive for highly qualified workers from outside the EU, privileged rules for family reunification with such workers were included in 3 EU directives. The Blue Card Directive, after the recent recast, today provides for 9 favorable derogations from the general rules of the Family Reunification Directive. Among others, no general rules, no pre-entry integration tests, no waiting period, faster decision-making, and immediate access to employment for the family members. Similar privileges were included in the ICT Directive and for researchers in the Students and Researchers Directive. Each time, economic reasons, human capital needs, clearly outweighed restrictive tendencies that prevailed in member states. This raises the question as to the fairness of the application, the continued application of these conditions and barriers to third country nationals with less education. Article 8 of the European Convention of Human Rights allows for interference with the right to family life, which is, and I quote, necessary in a democratic society in the interest of the economic well-being of the country. And the court in Strasbourg allows states generally a large discretion on this point. But does the economic self-interest sufficiently justify that spouses of highly qualified Brazilian, Chinese, or Indian citizens admitted for employment are exempted from the pre-entry language and integration test, while the spouses of third country nationals who were born and lived their whole life in the member state have to pass the test before entry? How could a less favorable treatment of spouses of static sponsors with Dutch or German nationality be justified? These questions become all the more urgent in Germany since the new Chancenaufenthaltsrecht reduced the language requirements for spouses of ausländische Fachkräfte, but not for spouses of comparable German workers. Secondly, the difference in treatment between refugees and beneficiaries of other forms of protection. The Family Reunification Directive provides for a privileged treatment of refugees only and allows member states to apply less favorable rules for beneficiaries of subsidiary protection. Most member states decided to apply the same rules to both categories. Germany and several Scandinavian countries decided, as we have already remarked, to apply less favorable rules in order to postpone family reunification of Syrian nationals in 2015. The governments argued that the protection needs of the other categories were only temporary. Time proves this argument to be wishful thinking. In the case MA versus Denmark, the court in Strasbourg held that a difference in treatment with regard to waiting periods could be justified in case of mass influx of refugees. A state may temporarily give priority to protection against Article 3 violations outside the country of origin over the Article 8 interest in family reunification. But the court set a limit. A waiting period may not last more than 2 years. By postponing consideration of these applications for 3 years, Denmark violated Article 8. In the later judgment, MT versus Sweden, the court held that a Syrian beneficiary of subsidiary protection with respect to the right to family life was in an analogous or relevantly similar situation to that of a person granted refugee status, and that the duration of the waiting period imposed had to be assessed in terms of its proportionality. These judgments may well have consequences for the justification of other requirements and practices which de facto postpone or block family reunification with beneficiaries of international or national protection. And then thirdly and lastly, the difference in treatment in the Dutch and German law exempting spouses of rich and Western countries from pre-entry language tests only on the basis of their nationality. The UN Committee monitoring CERT, the Convention on the Elimination of Racial Discrimination, the Council of Europe's European Commission Against Racism and Intolerance, and Human Rights Watch, all three concluded that the Dutch system of exemptions of family members from certain rich and Western countries involved violation of the prohibition of this discrimination. The Dutch government disregarded their recommendations. When a Dutch court referred the question whether this difference in treatment is compatible with the Family Reunification Directive to the court in Luxembourg, the Dutch government avoided a possible unwelcome answer by immediately granting a visa for family reunification to the Afghan spouse concerned. And the EU Court of Justice then held that the case was moot. And it so far has never dealt with the question whether the unfavorable treatment of non-Western spouses is compatible with Article 21 of the Charter. The Court of Justice, in another case, held that Article 21 of the Charter, insofar as it prohibits any discrimination based on ethnic origin, does not preclude a language condition. Which is applicable to all third country nationals without distinction. In the Netherlands, as in Germany, however, nationals of certain third countries are exempted from the test. The selective effect of the Dutch text varies considerably depending on the nationality of the spouse. Less than half of the spouses from Iraq and Sri Lanka passed the test for the first time, while the pass rate for spouses from Russia is near 100%. In recent years, only half of the participants with basic education, as opposed to 85% of the candidates with higher education, passed the test for the first time they took the Dutch test. This test discouraged family members with lower education. The accumulation of exemptions for spouses of highly qualified third country nationals and those from rich third country nationals makes it all the more questionable whether the application of the pre-entry test to other spouses is compatible with the right to family life and the prohibition of discrimination. For good reasons, the pre-entry language test is under critical discussion both in Germany and the Netherlands today again. Most family reunification rules on paper are colorblind, but their effects in real life are not. Immigrants from certain non-EU countries and Union citizens of immigrant origin experience the negative effects of these rules far more often than other native white Union citizens. Ich bedanke mich für Ihre Aufmerksamkeit.